Thank you, Chairman Roy, and thank you to our witnesses for being here today. When the chair began his remarks, with a concern about forces trying to undermine our Constitution, I thought we might have some unintended agreement, but unfortunately, I don't think that's the case. I can't think of anything more un-American than for members of Congress to be stoking fear and suspicion against fellow Americans or anyone else on the explicit basis of their religious beliefs. No matter what hysterical rhetoric we hear from our Republican colleagues, our Constitution is clear. In this country, people have the right to hold and express whatever religious beliefs they choose, or none at all. You don't have to agree with those beliefs, but no one can use the power of the government to punish or discriminate against those who do. There's nothing foreign or suspicious about that. In fact, there's nothing more American. Whether our colleagues actually believe the histrionic and unsupported statements they've made about Muslims and Sharia law, I'm not sure. But it does appear that today's hearing is the most recent expression of a cynical political ploy driven by the Texas Republican primary, where early voting starts in a week, and federal, state, and local candidates are trying to outdo one another with anti-Sharia, anti-Muslim sentiment in order to score political points. In the words of one Texas Republican political strategist, the Muslim community is the boogeyman for this cycle. It seems the pretext for all this bluster is a proposed real estate development in the Dallas suburbs led by the area's growing Muslim population, but there's no evidence it has anything to do with imposing Sharia law on non-believers of Islam. And there's no evidence it's a Sharia compound, as Texas Republicans have alleged. The Trump Justice Department itself closed an investigation into the development, finding no basis for any violation of fair housing laws. As with so many things Republicans bring to this committee, there's just no there there. But their view seems to be, as long as they can scapegoat someone or something for political gain, who cares, right? And it's entirely clear they don't care at all whether fellow Americans or others end up as collateral damage to the anti-Muslim hatred and fear that's being stoked. In addition, this hearing appears designed to support unconstitutional legislation. Last October, Chairman Roy introduced H.R. 5722, a bill that requires the government to, among other things, deny any immigration benefit, visa, immigration relief, or admission to the United States to any foreign national who adheres to Sharia law. It similarly directs the government to remove any foreign national already here if the government determines that the person is an adherent of Sharia law. This kind of government discrimination based purely on a person's religious beliefs, not actions, is a blatant violation of the First Amendment's free exercise and free speech guarantees. And to the extent that this bill implicitly favors Christianity or another faith over Islam by singling out Islam for government disfavor, could violate both the spirit and the letter of the Establishment Clause. By banning an adherent of Sharia law from the country, the bill essentially targets any observant Muslim for government discrimination. Sharia is concerned with guiding individual personal religious observance, not shaping national laws. Just as other belief systems guide the adherents of those faiths, Sharia guides Muslims in how to pray, dress, eat, or fast, and includes rules about marriage, divorce, and the raising of children. So to say that an adherent of Sharia law should be excluded or removed from the country is to say that all Muslims should be excluded or removed from the country because of their religious beliefs and observances. It goes against everything that America stands for, and we need look no further for confirmation of that than one of our founding fathers, Thomas Jefferson. In his autobiography, Jefferson wrote about what he considered one of his proudest achievements, the drafting of the Virginia Statute for Religious Freedom of 1786, a precursor to our First Amendment. He affirmed that religious freedom was meant to encompass within the mantle of its protection people of every denomination. In addition to expressing the fundamentally American belief in the right to freely practice one's religion and to prevent the government from favoring one religion over another, Jefferson's writings specifically reference, among other faiths, believers in Islam, illustrating that from our republic's earliest days, Muslims were intended to be included within the fabric of American life. The kind of demagoguery that this hearing represents is unbecoming of this subcommittee as one that is dedicated to the Constitution and unbecoming of members of Congress. Our attention should be focused on the Trump administration's repeated attacks on our constitutional order and on Americans' rights, including the rights to free speech, a free press, to peaceably assemble, to petition the government for redress of grievances. We shouldn't be furthering ugly Islamophobia and justifying a blatantly unconstitutional bill. It's shameful and it's un-American. I yield back.
I will now recognize the ranking member, Mr. Raskin, for his opening statement.
Kindly, Mr. Chairman, and thanks to the witnesses for joining us today. We live in a country so great that we don't need the anti-Sharia and anti-Muslim legislation our friends are proposing today, because our Constitution already forbids theocratic imposition and establishment of any kind at all, whether it's Christian white nationalism expressed in compulsory Ten Commandments displays, an Orthodox Jewish set-aside school district in New York, or any effort to replace secular public law with a religious sectarian code, whether that's Sharia law, the Analects of Confucius, the Torah, or anything else. So this completely unnecessary hearing, another distraction from the administration's cover-up of the Epstein files and the continuing brutal violation of people's constitutional rights in Minneapolis, is a wonderful opportunity to remind ourselves why our Constitution has 3 essential religion clauses and why they do all of the work that people are talking about doing today. The Establishment Clause, the Free Exercise Clause, and the clause guaranteeing no religious tests for public office. And if you take time to study them, they will dispel all the anxieties stirred up by legislation and agitation like this. Anything legitimate that our colleagues want to say about preventing the imposition of Sharia law in America is already accomplished by the Establishment Clause. So everybody can rest easy with Thomas Jefferson's wall of separation between church and state that he identified in his famous letter to the Danbury Baptists. Let's say someone proposes that all public schools and government offices should post the core principles of Sharia law, which I don't know what they are exactly, and I looked online and there were like 4 or 5 different versions, but let's take one which said protecting religion, life, family, intellect, property, and wealth. Another one said protecting honesty, trustworthiness, mercy, humility, moderation, and honoring promises. But whatever it is, if somebody said we want to put Muslim Sharia law up in all the schools and all the government buildings, we would know very quickly how to deal with that because we're not writing on a blank slate. In fact, we're in something of a furor over the laws compelling the posting of the 10 Commandments right now that were recently passed in Louisiana and Texas, but the Supreme Court already struck down such 10 Commandment laws in 1980, more than 45 years ago, in a case called Stone versus Graham, as a plain violation of the Establishment Clause, which forbids governmental endorsement of any religious text or any religious doctrine. We don't even have one agreed upon version of the 10 Commandments. There's a Catholic version, there's a Lutheran version, there's an Episcopalian version, many others you can find online. Which one would the government even endorse? Well, we've got members of this body who vehemently denounce Sharia law, but also agree with Louisiana and Texas that we should be posting the 10 Commandments of some particular sectarian variety up in the schools. When this came up last Congress, there were members of the Oversight Committee who said we should not only be putting the 10 Commandments up in public schools, but in Congress and all public buildings. I told them the 10 Commandments have been doing fine for millennia without an endorsement by the Freedom Caucus in the House of Representatives. One guy told me, well, you know the 10 Commandments are the basis for the Bill of Rights. I was kind of confused because, there are 10 in each one, but I said, let's test the proposition. The first commandment says, thou shalt have no other God before me. The First Amendment says, Congress shall make no law respecting an establishment of religion. So I don't think the First Commandment dictates the First Amendment. They wanted to go to the floor and have an up or down vote on the 10 Commandments. I said, if we're going to vote on the 10 Commandments in 2025, we should vote on each commandment separately. And you shouldn't be allowed to vote on any commandment you yourself have ever violated. That would make more sense. In any event, this is res judicata. It's a closed case. The government cannot endorse Muslim law, Jewish law, Christian law, Methodist law, Baptist law, none of it. So we don't need a special anti-Sharia law or a special anti-Sharia caucus. The First Amendment already takes care of it. Well, anything illegitimate or discriminatory that our colleagues would want to selectively impose on Muslims is conversely a violation of the Free Exercise Clause and also forbidden by the Constitution. Muslims afraid that Congress might actually impose one of these anti-Sharia bills, and of course they're just introduced for political purposes. I don't think they have any delusions that they're going to pass Congress. But if you were afraid of that, all you would have to do is read the case law to understand why that can't be done. Check out, for example, a case with the wonderful name Church of Lukumi Babalu I versus City of Hialeah in 1992, where the city of Hialeah in Florida selectively banned animal rituals and sacrifice by people practicing the Santeria religion. And the Supreme Court assuredly said, look, if you want to have general laws that apply to every religion and to every citizen that ban certain kinds of animal slaughter as cruel or unusual or particularly harmful, then you can do it. But you can't pass a law that targets a specific religion. Justice Kennedy called it religious gerrymandering. So I don't know, Mr. Chairman, about the East Plano Islamic Center, which sounds like a compound with a mosque and some residential and some restaurants and so on. And of course, those kinds of religious compounds exist all across America, whether we're talking about the Amish, the Mennonites, Catholics, Jews, you name it, lots of those exist. But they do violate a separate principle if the government actually clothes them with secular power. So I would agree with you, if they're giving them the power to set up their own police force, their own school system, that would violate the Supreme Court's decision in a case called Kiris Joel,